The Senzo Meyiwa murder trial is set to resume in the Pretoria High Court tomorrow. When proceedings adjourned last year, a trial within a trial was being heard to determine the admissibility of confessions made by 2 of the 5 accused. The Bafana and Orlando Pirates goalkeeper was killed in Vosloorus in 2014, and what the state claims was a robbery gone wrong. Legal expert Mpumelelo Zikalala joins us for more. Mpumelelo, great to speak to you in this half of the year. Let's look at a summary of where things ended last year. Amongst those was obviously that accusation against Judge Mkwatleng interfering in the cross-examination, according to Advocate Zulu, amongst some of the key highlights from last year.
Good evening to you and also good evening to our viewers. Certainly, I think it's still going to take a bit of a center stage because this type of the proceedings are mostly crucial in the sense that if the state is able to prove that these confessions are really authentic, then it makes the work of the state much, much easier. The state does have a burden of proving beyond reasonable doubt that the individuals that are in that dock are indeed they are ones that perform this horrendous act. So if they are able to get a confession, then it works in their favor. It tips the scales in their favor, and the chances of them getting a conviction are going to be increased, which is why this particular piece of evidence is contested as it is now. Now, that particular contestation is going to come with accusations if one is viewed as being barred from asking certain questions, if one is being coached as to how is it that they should answer, if certain questions are prevented from being answered by certain witnesses, then definitely you're going to find those complaints being there. You may also see those complaints taking place maybe within the 174 application that may follow after the end of the state case, or if the accused are found guilty, to form part and parcel of their plea proceedings to say, had you been a presiding officer that was fair, was able to give an equal opportunity to all members to state their cases, you would have been able to extract the truth as it is. And the part of the truth would have been that those particular individuals or the clients are not guilty. So we're going to see a lot of contestation taking place from now on.
Now, how's the trial progressed during the trial within a trial, focused on the alleged confessions made by 2 of the accused?
It is mostly, let's look at it as a two-stage approach. The first stage is should we accept this particular piece of evidence to fit into the bigger part of the puzzle that we are trying to assess? If we say yes, then it means that let's accept it, and the chances of that, or when it comes to crucial information such as these ones, it makes the job of the state much easier or much, much harder. So if you do have a confession, you accept it as a confession. So no matter what you say, or at a later stage come and say, as that particular accused individual, it's very difficult to undo the confession that you have made, because the court is going to draw an inference of saying you must be lying in one of the 2 instances. Either you lied during the confession or you are lying now. And the chances of the state coming to the point saying that you are lying now because you can see that there's a bit of a glimpse or a small light at the end of the tunnel in terms of you being freed from these accusations that you are facing, then the court is going to draw the particular inference. So that's why it's important that these particular processes be done and dusted and be executed in a proper manner at this stage so that you don't find yourself in any type of trouble.
I want to take you back a little bit, given the accusations of interference during the cross-examination by defence advocate Zulu and the subsequent adjournment. How has the relationship between the defence and the presiding judge, Mkwatleng, evolved? And could it potentially affect the proceedings going forward?
Well, in the bigger scale, I don't think so. Remember, when you go to court, it is a contested terrain. It does not mean that we have to agree with each other. However, the principles that are laid down in terms of the law and the practices that we engage in, those ones must be observed at all times. And that is where you would find when a person is noting an appeal, certain instances where they feel that the presiding officer was not doing their job correctly to note those particular processes. So you may find that it is either from the side of the defense saying that we want to place it on record because the proceedings are being recorded, that these are the type of things that we are not happy with, so that if we do lose this particular matter, we're going to take this matter on appeal. And taking that matter on appeal will then result in us highlighting all these instances in which we're interfering. Or it may be from the side of the presiding officer whose sole task is to make sure that things are moving swiftly, to say, I do not want you to ask frivolous questions which are not going to take us anywhere. I want you to ask questions which are going to assist this court in unraveling the truth and discovering whether the witnesses in the witness box is telling us the truth or not. So you do have the push and pull which takes place on a regular basis, but it does not mean that there's something wrong or either of the parties are misbehaving. And if either the parties are misbehaving, from the side of the judiciary, you do have the JSC, that's where you can go and complain. From the side of the legal practitioners, you do have the LPC, even though it is something that you do only at a later stage, unless it is so pressing to such an extent that you cannot wait up until the matter is done and dusted with. And your only reprieve that you might have as a defense attorney is to chat with the judge president to say, the person that you have allocated to handle this matter is giving us issues. Can you please come to our aid? Because justice is not going to be administered in a proper manner if we continue in the manner in which we are doing now. But from what I've seen from the start up until now, it's a normal course of business, normal concerted terrain as you would see in any courtroom, and it's not really anything to be alarmed about.
Delays upon delays is one of the key factors that we've looked at. Now, the defense advocate, Begum Ngomazulu, raising regarding his health condition, and how did the court respond to this request for an adjournment until January 2022, bearing in mind that the Deputy Judge President, Audrey Lidwaba, wanted the case resolved speedily?
It is something which is going to be looked at. Remember, it's the right of the accused to have the case start and end within the shortest reasonable amount of time. And what is the most worrying factor for both sides is that the longer you delay, the quality and the quantity of the evidence is affected. So the truth that you're trying to unravel, you're not going to find. People are going to pass on. Evidence may be lost. That is something that we don't want. And we're looking out for the number one individual, so the most important stakeholder here, which is the Meyiwa family, because they need to find out the truth. So any delays which are going to take place, they must be looked at in a proper manner. Now, the Criminal Procedure Act prescribes how those particular processes and investigations ought to be done. And as a presiding officer, you must look into it. There are things which are going to be unavoidable, by the way, like the health of the legal practitioner that has been chosen by the accused, or a legal practitioner that have taken the matter thus far and has intimate knowledge and they know the type of strategy that they want to apply. In instances such as those ones, then you should give them the benefit of the doubt. Health is important as much as these matters are, which is why I was taking a bit back in terms of, let's call it sarcastic comments in inverted commas of saying that we cannot continue with this matter because of 1, 2, 3, 4, 5, citing the health of the legal practitioner in a manner in which is not, many ways may view it in not being sympathetic to the health problem that the health practitioner is facing, because you never know. You may wake up tomorrow and you find the judge is actually the one that has a problem. So it's in those instances in which the decorum of the court and the proceedings must be respected by all parties. The manner in which these applications are done must be done in a proper manner, and they must be investigated with the sole purpose of saying that we do not want any delays which are going to be unreasonable. Delays must be unavoidable due to circumstances beyond the party's control, and you must make sure that you are able to move as swiftly as possible. And to even assess it on equally on both sides. And a number of instances in which the prosecution has not been ready with their witnesses. Now, it's not the fault of the accused that the matter can proceed on site. And the presiding officer must be as harsher to say, we are waiting on you to provide your witnesses. We are waiting on you to make sure that we're able to move faster. The longer we wait in this particular matter, that's when you're going to present problems. But the manner in which they've been handling the matters thus far, and the speed in which they've been moving into is definitely commendable. And I do think that maybe by the end of this year, the matter will be done and dusted.
Could be done and dusted by the end of the year, but it's obviously been one of the longest cases in history, if I might add. So let's talk about some of those issues in Mpumelelo that you raised around the delays in this trial proceeding, or aspects of this trial happening, and how the quality of the various aspects of the case become questionable. You know, witness statements, for instance. People start to forget, fail to remember what they were wearing or what they were not wearing. Can the defense use this to their advantage, or can any party use this to their advantage?
Definitely it can. Actually, it works for you and works against you depending on the man and the type of evidence which is being faced. So if someone not remembering anything, it works against the state because they have to prove beyond reasonable doubt. So if there are instances of doubt as to whether the color was red or blue, if there are instances of doubt whether the person carried the gun or not, instances of doubt whether there were 3 or 4 individuals within the house, and there's no collaborative evidence that is going to come in and support what the eyewitnesses are actually saying, then it is detrimental to your case. From the side of the defense, if you're not going to find someone who's going to be able to prove your alibi, for example, to say, on this day I was at work, I was working, here's the manager, and the manager has passed on, it's certainly something which is going to work against you, which is why it's important for these type of matters to be investigated quickly after the investigation has taken place, also to be prosecuted or to go through the court system in a much more quicker way. Now, it has taken 10 years or nearly 10 years for this matter to enter even into the court. And we must focus our attention to the law enforcement agencies and say to them, why are you finding it difficult to investigate this type of matters? If it was someone who was not a media personality or a popular soccer player, would this element of justice have been handled in a proper manner? Or was it going to turn into a cold case? If it's going to turn into a cold case, look into internal processes, make sure that you are able to investigate properly, make sure that you are able to prepare those cases so that they are ready for the prosecution to take over. That is what I think, especially the police minister and the commissioner must have been sitting and looking at these proceedings and saying, we must find ways of doing these investigations quicker so that you can be able to deliver justice to our members.
Now, with the trial scheduled to resume on January 22nd, what expectations or developments can be anticipated in terms of witness testimonies, legal arguments, and potential procedural issues? And I'm sure the families of Senzo Meyiwa and the accused individuals are keen for further delays to be averted.
It's going to take over or move on from where they left off. So the individuals that are involved in the confession part of it are going to still be called in. Any drivers that were driving the accused, any people that were present, any individuals that were pointed to, or they were saying, here's what you are saying, the evidence is here. Let's go on whatever right that we're taking on. Any sort of navigation or tracking companies would also need to be called if they haven't been called already. Otherwise, the alternative to that would be the parties will sit together and say, what admissions do we have? We're not going to contest this particular information. So if it is written in an admission form, then everything is going to be fine. It's going to be much quicker. So definitely expect the contested terrain to still continue. This one is important or crucial, by the way, because the admission of the confession means basically the end of the defense case, especially for accused 1, 2, and 3. So they're going to work as hard as possible to make sure that that confession is never regarded as a confession. It is totally thrown out by the court, and the burden of proof, it still goes back to the state to prove that on a sequence of events, that is what was taking place. After the end of the state case, which I don't think there are going to be maybe more than 5 witnesses which are still to come in, because they've covered basically every single part of the aspect of the case in terms of the evidence which is required. You may see the defense applying what we call Section 174 in terms of the Criminal Procedure Act, of saying we want to discharge an application to discharge these charges from the instance. There's no evidence that has been provided that places our accused or our clients inside the crime scene. There's no other evidence that says they are linked to this particular crime. So due to the lack of evidence, they're not going to even enter the witness box. Please discharge them so that they can be free. If that application succeeds, that's the end of the case, and the state may appeal that particular process. But if it doesn't, then the 5 accused will have to go into the witness box, and they will have to state their evidence and be cross-examined by the state in the effort of extracting the truth as to what exactly happened on that fateful night.
You know, Mpumelelo, when you do a 360 of this case, or a bird's eye view of this case, there are many things that went horribly wrong, whether it's the contamination of crime scenes and so on. In your view, what are some of these key factors that the judiciary, that the police and many other parties involved in this case will look at and think to themselves, well, you know what, if ever another case like this comes up, there are a great many things that we need to do differently?
You see, the most important one is the securing of the crime scene, because that's where you're going to get your information and evidence which is going to lead to a successful prosecution. So if they haven't started by now to say, when you enter a crime scene, this is what you do. The most basic, cordon off the crime scene so that no one else is able to contaminate it. Make sure that it is protected at all times. Make sure that the statements of the individuals that are protecting the crime scene are there, so the chain of the evidence is not broken in any manner. Secondly, those forensic experts that are going to come in, make sure that they are properly trained, they know what they're talking about, they know which information they're supposed to look at, they are able to anticipate in terms of where to search within that particular room. Also, that is going to be very important. And then thirdly, if you are taking a confession, the law is very clear in terms of the Criminal Procedure Act of the processes that ought to be followed. This is what you must do so that everything is done correctly. It shouldn't be that a magistrate is going to have to be called in order to provide evidence, because there are certain things that are perceived that were not done correctly. It must be clear from the paper, and it must be uncontested that the confession has been obtained. If you are able to do those things correctly, then everything is going to be done from the law enforcement agencies. From the side of the prosecution, make sure that your witnesses are there on time, they've been properly prepped. You know exactly what the witnesses are going to say and whether they're able to aid your case or not. The reason why I'm pointing to that, in this matter, we have a unique situation where you have two dockets, two investigations that have taken place. However, ordinarily you would expect that those investigations would be merged. In this case, they haven't been merged. You have one case on the other side and another one that's been prosecuted, and then you ask the question, why aren't you using the information that has been obtained by the same law enforcement agencies from the same South African police services to make sure that you are able to extract the truth and prosecute the right individuals and make sure that you come back with the conviction of the end of the day? So those are the things in which, if you were to write a case study about this matter, you certainly look at and say, make sure that you avoid investigating matters such as in this particular manner, and all the things that have been done which are good, make sure that you're able to increase and enforce them correctly.
Mpumelelo Zikalala, legal analyst, giving us a preview of the Senzo Meyiwa murder trial, which returns to the courts tomorrow. I appreciate your time.